Lawyer laughed at uneducated black clerk. Went silent when she cited case law he'd never heard of. The laugh was not loud. That was the thing about it. It was the quiet kind. The kind that does not need volume because it already has the room. It came from a man in a charcoal suit, standing at the far end of the clerk's counter in the Fulton County Civil Court. A thick accordion file under one arm, and the specific posture of someone who had been inside courtrooms long enough to mistake familiarity for authority. He was looking at the young woman behind the counter, and she had just told him something he did not like, and instead of responding to what she had said, he had laughed, briefly, with his chin slightly raised, and then turned to the other man standing beside him and said it quietly enough that it was clearly meant to be heard. Uneducated clerks citing procedure to me. In my own courthouse. The young woman behind the counter did not change her expression. She had a file open in front of her, and a pen in her hand, and she was looking at the man in the charcoal suit with the patient, level attention of someone who has heard a version of this before and has long since decided that the version does not change her answer. Her name was Simone Carr. She was 29 years old. She had a law degree from Howard University School of Law. She had passed the Georgia bar on her first attempt 9 months ago. And she was currently employed as a law clerk in Fulton County Civil Court, not because she could not find work as an attorney. She had 2 offers from firms, both of which she had deferred. But because she had made a deliberate choice, for reasons that would become relevant in approximately 11 minutes, to be exactly where she was. The man in the charcoal suit did not know any of this. He had looked at her, and he had seen a clerk behind a counter, and he had completed the calculation in the time it takes to form a first impression and committed to it the way certain men commit to first impressions, fully, publicly, and without leaving themselves an exit. His name was Warren Holt. He was a senior partner at Holt, Greer & Alcott. He had been practicing law in Atlanta for 26 years. He had appeared before more judges in this building than he could count. He had won cases he should have lost and lost cases he should have won, and had developed, through all of it, a working theory of the courthouse that located the clerk somewhere between the furniture and the filing system in terms of who mattered. He was about to discover the specific cost of that theory. Nah, hold on. She passed the bar and she's standing behind that counter by choice? We need to understand who Simone Carr is before we go any further, because this story is about a lot more than a laugh. Simone grew up in Macon, Georgia, in a house on a street that backed up against the fence line of a middle school, and she fell asleep most nights of her childhood to the sound of the maintenance crew running the lawnmowers on the athletic field on the other side of the fence. Her mother, Delphine Carr, worked as a paralegal at a small general practice firm in downtown Macon. Not a prestigious position, not a high-paying one, but one that Delphine had held with a fierce professionalism for 17 years, and that had given her a thorough, ground-level understanding of how the law actually worked in the lives of people who needed it. Delphine was the kind of person who brought work home not because the job demanded it, but because she could not stop thinking about it. She would sit at the kitchen table in the evenings with case files and a yellow legal pad and a cup of tea that went cold while she worked, and Simone would do her homework at the same table and absorb, over years of proximity, the texture of her mother's attention, the way she read, the way she traced a line of legal reasoning backward to find where it had gone wrong, the way she held a deposition transcript to up the light of a different question and found things in it that the lawyers in the office had missed. Simone asked her once, when she was about 13, why she did not become a lawyer herself. Delphine looked up from the legal pad. She was quiet for a moment, in the way she was always quiet before she answered something that deserved a real answer. Money, she said. Time. 2 children and your father's hours and a mortgage that didn't negotiate. She paused, dalt. And also, I was not sure back then that the room would have me. Simone thought about that answer for a long time. Not the pragmatic part, the money and the time, but the last sentence. The room would have me. She thought about what it meant to not be sure of that. She thought about the specific damage of not being sure and how it shaped the decisions you made before you ever got to the room. She decided at 13 years old, with the particular clarity that certain children arrive at before they know enough to doubt it, that she was going to be sure. She was going to walk into every room as though it had been built with her in mind. Not because she was naive about what those rooms were like, but because the alternative, editing yourself before you arrived, was a tax she was not willing to pay. She was a remarkable student. Not in the effortless, floating above it way of students who are talented without being hungry, but in the methodical, relentless way of someone who understands that the work is the work, and there are no shortcuts worth taking. She read everything assigned and then read around it. She developed an early obsession with the history of civil rights law that began with a biography of Thurgood Marshall she found on her mother's bookshelf at 14, and that expanded, over the following years, into a reading list she maintained in a spiral notebook she kept in her bag and updated the way other teenagers updated social media. She went to Spelman College on a full academic scholarship. She studied political science and African American studies and did not take a single course that she did not choose intentionally. She graduated in the top 5% of her class and was admitted to Howard Law in 2018, which was the outcome she had been working towards since she was 16 years old, and had first understood that Howard was where certain arguments about justice had been built into law. Howard Law was not a credential Simone wore on the outside. She did not talk about it the way people who are proud of something in the wrong way talk about it. But she had understood, from her first semester, that she was being trained in a specific tradition, a tradition that understood the law not as a neutral system, but as a terrain that had been shaped by power and that could be reshaped by argument, and that doing that reshaping required a level of precision and historical depth that most legal education did not emphasize. She had specialized in civil procedure and administrative law. She had developed a particular expertise in the procedural history of civil rights litigation, the way cases had been won and lost not on their merits but on the procedural grounds that determined whether they ever reached a point where merits could be argued. She knew the procedural record the way a musician knows a score. Not just the notes but the history of how the piece had been interpreted, the versions that had been tried and abandoned and revised. She passed the bar in 2023 and had 2 firm offers within 6 weeks. One from a mid-sized litigation boutique in Atlanta. One from a larger regional firm with a civil rights practice group that had done work she respected. She deferred both. What she had been thinking about, quietly, persistently, in the way she thought about everything that mattered, was the gap. Not the abstract gap between justice and law, which everyone in her field understood, but a specific, structural gap that she had identified through her mother's years at the paralegal desk and, through her own clinical work at Howard, and through a summer internship at a legal aid organization in Atlanta, the summer before her final year. The gap was procedural. It was the gap between people who had legitimate legal claims and the system that was supposed to adjudicate those claims, mediated by a set of procedural requirements, filing deadlines, form requirements, jurisdictional technicalities that were documented and accessible, but that, in practice, were navigated successfully almost exclusively by people who could afford lawyers who knew them. The courthouse clerk's office was where that gap lived. It was the first point of contact between a person and the legal system. It was where people with forms and questions and legitimate claims arrived without counsel and tried to figure out what to do next. And it was, in Simone's observation, systematically under-equipped to help them. Not because the clerks were inadequate, but because the role had been defined in a way that kept it at arm's length from the substantive guidance those people needed. Simone had a plan. The plan required understanding the clerk's office from the inside. It required knowing what came through the counter every day, what the actual patterns of procedural failure were, where the system lost people who should not have been lost. It required access that an attorney at a firm, filing documents from a distance, did not have. She applied for the clerk position in September 2023 and was hired in October. She told her supervisor she had a law degree. She did not advertise it. She came to the counter every morning with the same attention she had brought to everything since the kitchen table in Macon. And she did the work. And she learned what she had come to learn. And she was still learning it on the Tuesday morning when Warren Holt walked up to her counter with his accordion file and his 26 years and his quiet laugh. What had brought Warren Holt to the clerk's counter that Tuesday was a filing deadline. He was representing a corporate client in a civil breach of contract dispute, a case with a moderately complex procedural history. involving a prior dismissal, a refiling, and a question about whether the statute of limitations had been tolled during the period between the two filings. His associate had prepared the paperwork. Holt had reviewed it. He was at the counter to submit it. Simone had looked at the filing and identified a problem. The problem was technical and specific. The case had been originally dismissed without prejudice under a particular procedural rule, and the refiling had been executed on the assumption that a standard tolling provision applied to the gap period. What the associate's filing had not accounted for, what Simone had caught in the first 3 minutes of reviewing the documents, was that the specific tolling provision they were relying on had a line of case law running through the Georgia appellate courts that narrowed its application in breach of contract cases involving commercial entities. There was a 2019 Court of Appeals decision, Meridian Construction v. Blackwell Partners, that had clarified the limitation. If that case applied to Holt's filing, and Simone had reason to believe it did, the timeline as filed was potentially deficient, and a deficient timeline in a refilled case after a without prejudice dismissal was not a problem you could fix after the fact. She had explained this, carefully and precisely, standing at the counter with the filing in front of her. Warren Holt had listened for approximately 45 seconds and then laughed. "Meridian Construction," he said, to the man beside him, a younger associate who was carrying a second file and looking at his phone. "A clerk is citing Meridian Construction to me." He said it with the same quiet amusement he might use to describe an improbable weather event. Not cruel, just dismissive in the way that dismissed entirely. The associate looked up from his phone briefly and smiled the reflexive smile of someone who does not want to be the person who failed to find the senior partner funny. Simone waited. "I appreciate the concern," Holt said, turning back to her with the patient tone of a man explaining something to someone who did not need to understand it fully. "This filing is fine. We've reviewed the timeline. Just process it, please." Simone looked at him for a moment. Then she said, still in the same level voice, "Mr. Holt, I want to make sure you're aware that Meridian Construction was affirmed on appeal in 2021 in Vantage Capital Group v. Hargrove Development. The 2021 decision narrowed the tolling window in commercial entity refilings to 14 months from the original dismissal order. Your original dismissal order is dated 17 months ago. If this filing is submitted today under the current timeline, you may be outside that window." Holt stared at her, not with contempt this time, with something different. Something that happened in the specific moment when a man who has built a working model of a situation finds that a piece of the model does not fit. "Vantage Capital Group v. Hargrove Development," he said slowly. 2021, Simone said. "Georgia Court of Appeals, 3rd Division. Judge Elaine Tatum writing for the majority. It's not widely cited outside commercial refiling practice, but it's directly on point for this fact pattern." The associate had put his phone fully away. He was looking at Simone with an expression that had moved several positions from where it had started. Holt said nothing for 5 seconds. Then he said, "Can you pull that citation?" Simone had already written it on a notepad. She slid it across the counter. He picked it up. He looked at it. He looked at Simone. He looked at the filing in his hand. The room was not loud. Courthouses are rarely loud. But the quality of the silence in that particular stretch of counter had changed in a way that everyone within earshot had registered, including 2 other clerks who were not visibly paying attention and entirely were. "Hold on. I need you to feel what just happened there." He came to that counter with 26 years and a laugh, and she handed him a citation on a notepad. "Let's see where this goes." Warren Holt stepped away from the counter. He moved to the far end of the public area near the windows and made 2 phone calls. The first was to his associate, who was already standing 6 feet away, but who Holt apparently preferred to speak to by phone in this instance, because the call lasted 4 minutes and involved Holt's voice dropping to a register that did not carry to the counter. The second call was shorter. It was to someone at the firm. Simone inferred from the fragments she could hear that it was the partner who had originally reviewed the case, because Holt used the phrase, "You should have flagged this twice." After the second call, he came back to the counter. He set the accordion file down. He did not look immediately at Simone. He looked at a point on the counter somewhere between them for a moment, in the way that people look when they are organizing what they are going to say. "I need to pull this filing," he said. "We need to review the timeline." "Of course," Simone said. There was a pause. He was a man who had spent 26 years in rooms where he controlled the pace of things. And this was a moment where the pace was being set by someone else. And he was adapting to it with the particular stiffness of a man who was not accustomed to that position. "Where did you study?" he said. Simone looked at him. "Howard University School of Law," she said. "Class of 2023. He absorbed this. He looked at the notepad with the citation. He looked at Simone with an expression that had traveled a significant distance from the one he had brought to the counter 30 minutes ago. "You passed the bar?" he said. "First attempt," she said. "Last March." He was quiet for a moment. Then he said something that she did not expect, not because it was generous exactly, but because it was honest in a way that surprised her, and she had learned to appreciate honesty in any form it arrived in. "I owe you an apology," he said. "What I said earlier was wrong, and you may have just saved my client a significant problem." Simone nodded. She did not say it was fine, because it was not entirely fine, and she was not in the habit of resolving other people's discomfort by telling them that the things they did not matter when they did, but she also did not extend it. The account was noted. She moved forward. "Do you want me to pull the full Vantage Capital text from the system while you're here?" she said. "It might be useful to have it before you rework the timeline." He said yes. She printed it from the court's legal database and handed it across the counter without ceremony. He took it with both hands, which was not something he had done with anything she had given him earlier in the conversation. He gathered his things. He thanked her. He left. His associate, passing the counter on the way out, paused for half a second and looked at Simone. He did not say anything, but the look was not the look he had come in with, and she noticed the difference and filed it away with everything else she noticed. What happened after Warren Holt left the counter that Tuesday morning was not a single event. It was a series of events, connected by cause and effect, that unfolded over the following 3 months in the specific way that things unfold when a story has been building toward its own resolution for longer than anyone involved fully understands. The first event was the phone call. Holt returned to his firm and reworked the filing with his team, incorporating the Vantage Capital limitation and adjusting the timeline accordingly. The revised filing was submitted the following Thursday and accepted without issue. The case proceeded, but the conversation at the counter had not left him, and he was a man who, for all his faults of assumption, was a genuinely skilled attorney, and genuinely skilled attorneys tend to be honest with themselves, eventually, about the things they get wrong. He called the court clerk's office on Wednesday morning, the day after he had pulled the original filing, and asked the clerk, who answered, whether it would be possible to speak to the woman who had reviewed his submission the day before. He was given Simone's name, which he had not thought to ask for at the counter. He left a message. Simone returned the call on her lunch break. The conversation lasted 12 minutes. Holt asked her directly how she had known the Vantage Capital case. Simone explained, not in full, because it was a lunch break, but enough. She described the work she had been doing since October, the patterns she had observed, the specific procedural gap that she had come to the counter to document. There was a silence on the other end of the line that was different from the silence at the counter. It was the silence of a man who was thinking. "What are you going to do with what you've found?" he asked. Simone told him. She described the proposal she had been developing, a pilot program to provide procedural guidance to pro se litigants at the point of filing, staffed by supervised law students and law school graduates in the period before bar admission, positioned within the clerk's office as an extension of existing services rather than a separate legal aid entity. She described the 3 law school partnerships she had already identified. She described the funding model. She described the 2 judges in the building who had informally indicated they would support a formal proposal. He was quiet again for a moment. "Have you spoken to anyone on the court's administrative committee about this?" he said. She said, "Not yet." He said, "You should, and if you want someone to co-present it who's been in front of that committee before, call me." Simone did not say yes immediately. She was not in the habit of saying yes to things immediately, especially things offered by people who had, 24 hours earlier, laughed at her over a counter. She thought about it for a day and a half, and she talked to her mother, and she talked to her former professor at Howard, who had supervised her civil procedure clinic. And then she called Warren Holt back and said, "I'll take the co-presentation, but I'm leading it," he said. "I wouldn't have it any other way." She noted, without particular warmth or coldness, that this was the correct answer. She moved forward. The second event was the meeting with Judge Patricia Owens. Patricia Owens was a Fulton County Superior Court judge who had been on the bench for 14 years and who had, for most of those years, watched the volume of pro se litigants in the civil courts increase in a pattern that the administrative budget had never caught up with. She was 61 years old, meticulous, and had developed a reputation for being interested in the structural rather than the symptomatic. She wanted to understand why a problem kept occurring rather than repeatedly applying the same partial remedy to it. She had heard, from one of the clerks, who worked under Simone's supervisor, that there was someone in the filing office who had built something worth looking at. She requested a meeting, not through the administrative channel, directly through the supervisor, an informal 30 minutes during Simone's lunch hour on a Thursday in March. Simone brought a 12-page summary of the proposal, printed and spiral-bound, with an executive overview on the first page that gave Judge Owens everything she needed to know in the time it took to. Read 3 paragraphs. She had learned from her mother's legal pad, and from 3 years of law school, and from 4 months behind the clerk's counter, that the person across from you had a finite amount of attention, and that the job of the person presenting was to use that attention with respect. Judge Owens read the overview. She turned to the data section, the section where Simone had documented, across 4 months of observation, the specific procedural failures that had led to dismissed filings, missed deadlines, and lost cases among pro se litigants who had legitimate claims. The data was not anecdotal, it was systematic. It had categories and frequencies, and in a final column that Simone had added in the last revision, a conservative estimate of the number of meritorious claims that had likely failed on procedural grounds alone in the previous 12 months. Judge Owens looked at that column for a long time. "How long did it take you to compile this?" she said. 4 months, Simone said. "Concurrent with the filing work. Who helped you?" "No one yet," Simone said. "This is the document I needed to have before I asked anyone to help." Judge Owens looked at her over her reading glasses with the expression of someone recalibrating an estimate upward. "Tell me about the funding structure," she said. Simone told her. She described the 3-year pilot model, the law school partnerships, the supervision protocol, the evaluation metrics she had built into the design so that the program's effectiveness would be measurable from the first cohort. She described the co-presentation she had arranged with Warren Holt for the administrative committee, and she described, without editorializing, how that arrangement had come about. Judge Owens listened. When Simone finished, she set the document down on her desk and looked at it, and then looked at Simone. "You deferred 2 firm offers to come sit behind that counter." She said. "Yes," Simone said, "and this is why. This is why." Judge Owens nodded slowly. It was the nod of a person who has spent 14 years watching people arrive at her courtroom with problems that should have been solved before they reached a courtroom, and who has just seen a document that suggests someone has been paying attention to the same thing from a different angle. "I'm going to make 3 calls this afternoon," Judge Owens said. 2 of them are to people on the administrative committee. One of them is to the dean of a law school that has been asking me for 2 years how they can make their clinical program more useful to this court. She paused. "I'd like to add my name to the co-presentation if you'll have me." Simone said she would. She walked back to the filing office from that meeting and sat down at her desk and opened the spiral notebook she had been keeping since she arrived. In October, the one that was filling up the same way her mother's legal pads filled up, line by line, case by case, pattern by pattern, and she wrote the date in 1 sentence. "Judge Owens is in." Then she went back to the counter. There was a line. The co-presentation to the Fulton County Courts Administrative and Rules Committee took place on a Wednesday morning in April. The room held 22 people, 11 committee members, 4 court administrators, 3 law school representatives, 2 legal aid organization directors, Warren Holt and Patricia Owens, who was not a committee member but whose presence in the room carried the specific weight of a judge who has decided something matters. Simone presented for 38 minutes. She had prepared for 6 weeks, But the preparation did not show as preparation. It showed as clarity. She moved through the problem, the data, the proposal, and the implementation model, with the economy of someone who has thought about a thing so thoroughly that there is nothing left to perform. She anticipated every question before it was asked, not because she was showing off, but because she had sat at that counter for 4 months and knew exactly what the objections looked like. Warren Holt spoke for 11 minutes. He described the Vantage Capital incident without using Simone's name. He said only that a member of the filing office staff had identified a procedural deficiency in his own submission that his team had missed, and that the incident had clarified for him the degree to which the clerk's office was operating as an informal legal safety net, without the resources or structural support to do it well. He did not use the words of a man performing contrition. He used the words of a man who had looked at a data problem from a new angle and was describing what he saw. When he sat down, the committee chair asked the first question. It was directed at Simone. "The data in Section 3, the chair said, tapping the document in front of him. The column estimating meritorious claims lost on procedural grounds. How confident are you in that estimate?" Simone said, "Conservative. The methodology is in the appendix. I used a narrow definition of meritorious to avoid overstating the case. The real number is likely higher." The chair looked at the appendix. He passed the document to the person beside him. The questions continued for 40 minutes. Simone answered all of them. Judge Owen spoke twice, once to describe what she observed from the bench, about the downstream effects of procedural failures at the filing stage, and once to say, directly and without elaboration, that she thought the proposal was the most practically useful thing she had seen come before the committee in 3 years. The committee voted to approve a 1-year pilot at the end of the meeting. The vote was 11-0. After the meeting, as the room was clearing, Warren Holt found Simone near the door. He did not make a speech. He said, "When you're ready to leave the clerk's office, I'd like to have a conversation about a role at the firm, civil litigation. The kind of work where knowing Vantage Capital Group v. Hargrove Development by heart is an asset rather than a surprise." Simone looked at him. She had thought, more than once in the preceding weeks, about how she would handle this moment if it came. "I'm not ready to leave the clerk's office yet," she said. "The pilot needs a year. But I'll remember you said that." He nodded. He left. She stood in the emptying room for a moment. The chairs were still arranged from the presentation. The committee's copies of her proposal were stacked on the table, marked up, some of them, with notes in the margins. She looked at the stack and thought about the legal pad on the kitchen table in Macon and the cup of tea that was always cold by the time her mother remembered it. She took out her phone and called Delphine. "The committee approved it," she said when her mother picked up. There was a sound on the other end of the line that was not words. "Mama," Simone said. "I heard you," Delphine said. Her voice was steady, the way it was always steady, but underneath steadiness was something that Simone recognized from a lifetime of listening to it, the sound of her mother, allowing herself to feel something fully, without managing it down to a size that was easier to carry. "I'm going to need help staffing it," Simone said. "I need someone who understands the paralegal side of what happens at that counter, someone who knows what gets missed." "Simone," her mother said, "I know it's a lot to ask." "I've been waiting 17 years for someone to ask," Delphine said. The pilot program launched in September of that year under the name the Clerk's Access Initiative. It was staffed by 6 law students from 3 Atlanta area law schools, supervised by 2 licensed attorneys rotating on a voluntary basis, one of whom was Simone, who had passed the bar, completed the pilot's first operational year, and then finally accepted a position at a civil rights litigation firm in Atlanta, whose pro bono practice she had been following since her 2nd year at Howard. She stayed attached to the initiative as a supervising attorney, showing up at the clerk's counter twice a week in the early months, then once a week, then on the Fridays when the student cohort had their weekly debrief and needed someone to think through the hard cases with them. Delphine Carr joined the initiative as a paralegal consultant in its 2nd month. She worked 2 afternoons a week, and she brought 17 years of paralegal knowledge and the specific attention she had developed at the kitchen table, and applied it to the counter in the way she had always applied her knowledge, methodically, carefully, and with the complete focus of someone who had never once in her career phoned it in. She did not find the role glamorous. She found it necessary, which she had always considered the more important thing. In the initiative's first year, it assisted 431 pro se litigants with procedural compliance at the filing stage. Of those, 212 had filings accepted that would otherwise have required resubmission or risked dismissal. A follow-up analysis conducted by a Howard Law professor in partnership with the initiative found that the meritorious claim estimate from Simone's original proposal had been, as she had told the committee, conservative. The real number was higher. A local legal journal ran a feature on the initiative in its second year. The article described the program's origins, its data, and its impact. It quoted Judge Owens. It quoted Warren Holt, whose remarks were brief and careful and more honest than most public remarks by senior attorneys tend to be. It quoted Simone at length. Near the end of the article, the journalist noted that the initiative had been conceived and designed by a person who had spent 4 months as a law clerk in the filing office. A Harvard law graduate, the journalist had incorrectly written, and the correction published the following week specified. Howard University School of Law, Class of 2023. Simone saw the correction. She texted her mother a photograph of it. Her mother texted back a single line. Howard, not Harvard, get it right. She sent the same correction to the journalist herself politely, with the specific case citation for a Howard Law alumna, whose procedural argument had shaped the very area of law Simone had built the initiative around. The journalist thanked her. The article was updated. Simone noted it in her notebook, the one she had been keeping since the first week at the counter, and she closed it, and she slid it into the drawer beside the drawer that held the spiral notebook from her Howard clinic, which sat beside the reading list she had started at 14, which started with a biography of Thurgood Marshall. The line ran from there to here. It had always been going to run from there to here. The only question had been whether she would follow it with enough patience, and enough precision, and enough willingness to sit at a counter in a courthouse and do the work that most people, with her credentials, would have considered beneath them. It was not beneath her. Nothing honest was beneath her. Her mother had taught her that at a kitchen table in Macon, over a cup of tea that was always cold by the time she thought to drink it, and Simone had never forgotten it, and she never would. That's Simone Carr. That's the Clerk's Access Initiative. That's what happens when someone with everything to offer walks through a door that everyone else assumed she had no reason to enter. This story is fiction, but the gap it describes, the procedural gap, the place where people with legitimate claims get lost because they don't know the right citation, that's real. It exists in courthouses right now, and the people who close those gaps are almost never the ones the system was designed to make comfortable. Here's what I want to ask you. Have you ever been in a room where someone decided who you were before you opened your mouth? And have you ever had the moment where you got to show them something they weren't ready for? Tell me in the comments. Drop your story. I read everyone. If this one moved you, hit the like button. Share it with someone who's been underestimated and is still doing the work anyway. Subscribe. We have more of these coming, and everyone is worth your time. We'll see you in the next one.